We're going to be talking about the do's and don'ts of separation and divorce. And Michelle Dellino of Dellino Law Group is going to be doing most of the talking tonight. This is a webinar for anyone who is interested in learning about this topic. There's lots of, different questions and answers to be had within this broad topic. And so what we're going to do is kind of go through a bit of an agenda that Michelle has around some basics around do's and don'ts of separation and divorce, and then we'll be available for your questions. So I want to direct you to the question and answer section at the bottom part of your Zoom meeting. You can go ahead and plug questions into there if you have them, and we will answer those throughout the webinar. If you want to have your question marked anonymous so that nobody can see the name of the person who is asking the question, just go ahead and be sure to mark it anonymous. You can also ask questions in the chat. The chat will only come to me. And so, feel free to go ahead and ask it in the chat if you prefer. But either one of those methods works to shoot your questions to us during this time. So I'm Melissa Rosenberg. I'm a licensed independent clinical social worker. I'm a therapist. And I work with a specialty in relationship transitions. So I work with people who are either contemplating going through separation or divorce, or who are undergoing the process and could use a little bit of extra support given how emotionally challenging it can be. I also work with couples, and I work with individuals and couples in kind of an ambivalence or discernment state when they're trying to determine whether or not ending the relationship is the right move. I work in conjunction and in collaboration with Michelle Dellino and her firm, and I'm happy to be here today. So Michelle, I'll let her go ahead and introduce herself, and then we'll go ahead and get started. Thanks for joining us.
Yeah, thanks for joining us. I'm Michelle Dellino with Dellino Law Group. Dellino Law Group is a family law firm. We have 2 offices in Seattle, one in North Seattle up by University Village, one in South Seattle near in Georgetown, not near Georgetown. And we have a satellite location in Bellevue. We also serve clients in King, Pierce, Snohomish County, also in Kitsap County, and occasionally in the wilds of Thurston County, and also elsewhere on occasion. A little bit about me. My practice is focused on complex family law. I also do post-nuptial and cohabitation agreements, a little bit of estate planning. We have 5 other family law attorneys in the firm as well, in addition to me. So we do all kinds of family law. Today, we're going to talk about the do's and don'ts of separation and divorce. So we're going to cover some things you should do, some things that you absolutely should not do, some things you've probably thought about before, and some things maybe you haven't thought about. Who's this webinar for? It's for anybody who is thinking about divorce, people that might already be in the process as well. It's for you. It's really for everybody. It's for anybody who just wants more information about the process as we go along. I'm going to talk about some basics about separation and divorce. I'm going to, like I said, talk about some do's and don'ts, because that's always something people want to know about. And then probably most importantly, we're going to take your questions if you have them. A note about confidentiality. Like Melissa said, if you submit questions to her, you can mark them as anonymous, so no one's going to know what questions you asked. If you have really specific information, we'll give out information later how you can schedule a confidential consultation. Any information that you share with us today, we're not going to share it with anyone later. If other people that are here today choose to share, the fact patterns that you might share, we can't do anything about that. But your information is not going to be shared from this webinar. So what I'm going to do is I'm just going to start kind of with the question you may or may not have, which is, where do I start? Because that's what everybody wants to know. A lot of people think, where do I start? And so something that I find interesting when I started doing divorce over a decade ago was people think about divorce on an average of 2.5 years before they ever do anything. The average person who's thinking about leaving a marriage or a partnership thinks about doing that for the average of 2.5 years, is what most studies show, before they ever take any action. So if you've been thinking about leaving your relationship, or a relationship has been left that you're in, it's not something that usually happens overnight. Sometimes you know that because you may have engaged in couples therapy or maybe your own individual therapy. And if you didn't do that, maybe your other partner did, or maybe you wish you'd had that opportunity. And if you haven't, it's something that we definitely recommend. And as someone who does divorce, one of the reasons we partner with Melissa especially is because, and as someone who's been divorced, and who's now remarried, but as someone who's been divorced, I think that every marriage deserves a chance to try and look at whether it's something that you can try and correct before you go down the divorce path, because marriage is, what I always tell people, the most involved legal contract that you've ever entered into, whether you realized or not when you did it. So if you're going to end it, number one, you want to do it right, and you want to do it with the right help. And number two, you want to make sure that it's the right decision for you emotionally and financially before you go down that road. So therapy is a good option before you do that, either to be ready or to plan and make sure that it's what you want to do. But where do you begin? So there's really no right and no wrong answer to that. And where you begin really should be where you are. For some people, where you begin is to begin thinking about that process. For other people, where you begin is, I need to get out now and I need to know how to do that. So really where you begin is where you are. And like I said, that's not the same for everyone. Divorce, especially in King County, a lot of people they want to rip that Band-Aid off. A lot of people that come in to speak with us, they want it to be over and they want it to be over with now. And I can't stress enough to you, if you're in that position, that divorce is a marathon, it is not a sprint. So you can't come in today and say, I want to be divorced tomorrow. It doesn't work that way. If you're in Las Vegas, you might be able to be, I want to be married today and be married tomorrow, but divorce doesn't work that way. Washington law actually provides for divorce faster than a lot of other states does. So the fastest you could possibly be divorced in Washington, and some of you may know this and some of you may not, but the fastest you could be divorced in Washington is on the 91st day from the date that your divorce is filed and either served on the other party, or the other party either joins in your petition or accepts service. So some states you have to wait a year, and some states you have to wait a year of being separated before you can even file a petition. That's not the case in Washington, but you do have to wait 90 days from filing in service or filing an acceptance of service. So 3 months is a minimum. And I will tell you that that's in an agreed divorce or in a divorce where you're able to negotiate terms very quickly. The average divorce in King County, even where things are somewhat agreed or have to be negotiated, is more like 6 to 9 months. And for a case that actually has to go to trial in King County, you're looking at probably 12 to 18 months, especially right now, with how long things are taking and with some of the slowdowns that have happened in the courts. So divorce is a marathon, it's not a sprint. And like I said, please keep in mind that it is, marriage is a legal contract. And it's something that you need to dissolve and do it with your future in mind. So that's kind of the timeline for divorce when you start thinking about it. Another question that comes up just as we start talking about initial things is, how do I know when to leave? I've had a lot of people come in the initial stages, and I actually had a client who I first met with 4 years ago, just the other day, decide they wanted to move forward. And a lot of the time people come in and they don't know, is this the right time, or how do I know when to leave? And, I never want to push anybody to say, hey, this is the time you need to file for divorce, or try to scare anybody into thinking it's time to file for divorce. Because when to leave is a very personal decision. And sometimes you need to leave because there might be domestic violence going on. And that's not something that a lot of people want to talk about. Maybe not with their attorney, even though you should, because you have options available to you. If DV is going on in your relationship, but it's something that you should talk to friends and family about. But there's other kinds of abuse besides DV. There's emotional abuse. There is financial abuse. There's all kinds of things. And you can also leave not because you're being abused, but just because you're unhappy and because you've grown apart from someone and your situation's not working anymore. So why you leave and when you leave is a very personal decision, but sometimes people think, oh, I can't afford it, or it might not work for me. And there's never really like a right time. And sometimes the situation also gets made for you and someone else decides to leave. So, and that can also be a really hard place to be in. So when to leave or when someone else leaves is something that comes up a lot. And that also too, sometimes is when I also refer people to Melissa or to other therapists, because I can't necessarily tell you that. I can tell you, here's what we can do. Here's how we can make sure you have financial resources. Here's how I can make sure you have time with your children. Here's how I can decide who's going to stay in the family home, and all these other questions that come up legally, but I can't tell you, when to execute. And that's when Melissa or somebody like her really gets into that divorce ambivalence and helps you with that. But that's something that comes up a lot. So when to leave, or when someone else leaves, and dealing with coping with that is something that everybody struggles with. So if you're struggling with that, you're completely not alone. I've been, working with clients around that in many, many years, for many years. From there, I think it's important to talk about too, another question that comes up. A lot of people will come to me and they'll say, well, what if I move out? Am I giving up rights to the family home? A lot of people will say that. I don't feel like I can leave the house because then I've given up rights to the home. I don't know why people say that, but they do. And maybe I don't know why, but that comes up a lot. And I just wanted to get that out there when I'm talking about initial things, and say, if you move out of the home, you're not giving up rights to the home. You can't change the character of the property. If the home is presumed to be community property, and we'll talk about community property in a few minutes too. If you guys lived in that home together during the marriage, if you bought the home during the marriage, or when you lived together, if there's a presumption that it's community property, just because you moved out, maybe to get away from a bad situation or to separate at the beginning of a divorce or before you file for divorce, you're not giving up your rights to the property. So it's okay to move out, or if your wife or husband or spouse or partner, or however you like to characterize them, moves out, it doesn't mean they gave up their rights to the property. So don't think that, or don't worry about that. If you have questions about signing something, that's a different situation. You should talk to your attorney. But if you need to move out or leave, leave the property, don't think that you're giving up your property rights. I get that question all the time. And no, just because you leave the property doesn't mean you're abandoning it, doesn't mean you gave up your property rights. That's just something I wanted to toss out there, because that's like a really common question. So first steps, let's talk about first steps. This is something that people say, where do I start? And like I said, where you start is where you are. But first steps, I always like to tell people, I think we put this on our website at one point, but gather your resources. So what does that mean, right? Yeah, it's like, sounds like a buzzword, but it's really more than that. Gather your resources. Three kinds of resources I like to talk about. One is sort of what I've already talked about a little bit, emotional resources. Because this is a marathon and not a sprint, you're going to need people in your life to know. The people that I have had as clients that have been the most challenged in going through the divorce process are the people that try to keep it from everyone. The people that might be like, oh, we haven't told our parents yet. I don't want my elderly parents to worry. Or no one in our family knows that this is going on, or our friends don't know, or we're trying not to tell our kids yet. It's the people that are really not wanting people to know are the people that are struggling the most, and also the people that spend the most on attorney's fees, because they're having to talk to us the most about how to navigate those things when, and I understand maybe it's a difficult, nuanced situation. We definitely deal with that, but you need to come up with a plan. And part of that is emotional support and a game plan for dealing with that. And you're going to be juggling a lot of balls during this process. So getting your house in order for how you're going to deal with it, with your support system, and as much as possible with those in your life is important. The less you have to deal with that and with how other people are going to deal with your separation, the better. So making sure that your family knows, and they know, hey, I'm going to be dealing with this. This is what's going on, the better. Because if you're worried about like your parents knowing, or your siblings, or, the kids finding out, I mean, those things are just really difficult. You don't need that. So it's best if you can kind of get who your core support people are going to be aligned, and then get if you and your spouse can get aligned, if you have children, with how they're going to know, so they don't find out, or you don't have to worry about the other party telling them. If it's a really contentious divorce, where it's a situation where you just have to have this other person served, and it's not going to be some great conversation sitting down with the kids, you are going to want to plan that with your attorney on how that's going to go. But or a counselor or a therapist, and telling the children, or there's different ways, but have people know, because if you don't, that's one more thing you have to worry about. And it's also one more thing that could be weaponized and used against you in the divorce, which you don't want. And we'll get to that later. So emotional resources. Second one is financial. Divorce can cost you a little or it can cost you a lot. It depends on the kind of divorce that you have. Ideally your divorce isn't going to cost you a lot, and it doesn't have to. If you and your spouse can work together, and ideally if you have assets, you're going to want some advice in doing that. You should have advocates to help you get through your finances and each make sure that you're getting a fair deal. But at the same time, you can do that in a cost-effective manner. However, not everybody's lucky enough to be in that situation, and sometimes there's a lot to fight about. So like I said, your divorce can cost you a little or a lot. It really depends on your situation, but little things like the filing fee in King County is $316.49. Getting competent legal help, making sure that if you're going to need to line up a therapist if you don't have one for emotional support. Are you getting somebody that's on your insurance? Do you have somebody that's out of network that you're, billing? Do you have, childcare set up for that? Do you have, access to your own bank account? Like if you guys only have a joint account, go set up your own bank account so you know that you're going to be able to spend money and not, move money into your account and spend money and not know that your spouse doesn't have transparency into every single penny that you're spending. Start to build some financial independence and start to make sure that, you can afford what you're going to be doing. And if you have questions about that, get some help, get some advice on it, because I think building financial independence is something that's really important. And a lot of people feel stuck and they feel they can't leave a relationship because they've never done that. So that's something that's extremely important. So I would encourage you to talk to your support network about that. Also talk to your attorney about it. One thing that we do with our clients is if you're in that situation, we will connect you with other resources about, how to kind of set up a plan and start to rebuild your financial life, because a lot of people, they have never had to pay a bill before. Sometimes they don't know what's going on. And if you don't have access to resources for fees, like let's say the other person has controlled all the money, that's something too that you need to start to explore. And professionals. So there's going to be professionals that are involved. Like we already talked about, maybe you need a therapist because you should have somebody help you cope with stress. You probably need an attorney. We could talk about how to find the right kind of attorney for you. The right kind of attorney there's not a one size fits all thing, right? Like we'll talk about that too. You might need to work with a certified divorce financial analyst in working through your finances, because maybe you guys need to divide some resources, and for you, it might be better to take part of a 401k. For the other spouse, it might not be. So one thing we do with our clients is I work with different CDFAs, different CPAs. So if I need to make a decision on tax consequences, I'm going to consult with somebody who does that because I'm not a tax attorney. So things like that. You also too, in your case, if your case is a hotly contested case with parenting issues, you probably will have a guardian ad litem or a parenting evaluator in your life. And you're going to lean heavily on an attorney to tell you who's the right person for your situation. You're not necessarily expected to know that because this isn't what you do every day. And so you really shouldn't know that. But that person's going to be really important for you. And other things like that. So there's other people in your life too. You might need a realtor if you're going to be selling a home. So you want someone that you know and trust that deals with these kinds of situations. All kinds of professionals might come in your life. So emotional support, financial support, professional support. Those are the resources that you're going to need. Those three are going to be really critical for you. Other first steps you're going to want to take in the divorce process. One of them is document gathering. When you start to work with us, one of the things we do is we send you a welcome letter, basically telling you, hey, this is what it's about working with us. This is what our team does. And then we send you a list of financial documents we're going to need from you. And some people are like, wow, this is a lot of homework. This is super overwhelming. And some people say, I just don't have all this information. And if you don't, totally okay. But if you do, it only helps us and it helps you because number one, it's information the court will eventually want. And number two, it helps us help you reach a fair settlement and have transparency into what the finances are. And so most attorneys will say, we want to get a look at what the finances are so we can help you determine what a fair settlement would be. So what you can do when you're starting to prepare for the process is get a head start on that and get together things like the last 2 years of your tax returns, including your W-2s. That's something that you're going to want to get. Your pay stubs for the last 6 months. That's something you're going to want to get. If you don't have pay stubs for the last 6 months, if you have unemployment, you're going to want to get that information. If you're self-employed, you're going to want to get profit and loss statements. That would be super helpful. Also, too, if either party owns 5% of more or more in a business, King County courts will require you to have business bank statements and corporate tax returns as well for the last 2 years. You're also going to want to get all, and when I say all, I really mean all. People are like, all? What does that mean? Does it mean one bank account? No, it means all. It means all statements related to any account that you have a financial interest in for the last 6 months. So that means your mortgage statements, your credit card statements. It means kind of all your statements for the last 6 months. So then we know, do you have retirement accounts? So then we see everything you have, and we can put together an asset and debt spreadsheet for you, and we can see what really fits into the community. And then once we know what's in the community, we can help you figure out what you have to deal with, and we can help guide you better. So start getting together your financials, because no matter what attorney you work with, they're probably going to ask you for them. And if you don't have them, that's okay. There's other ways to deal with that. But if you do, it's something you can do to save yourself time and money and kind of get a head start on them. So that's something you can do to sort of check it off your list. Another thing I'm going to talk about really quickly, which is something that a lot of people don't think about. Well, maybe you do. I don't know. It's the new millennium, right? I guess we're past that. Is social media. Social media, as somebody who litigates, I can tell you, and who mediates a lot, social media plays a huge role in separation and divorce. So everybody has some kind of social media account. Before, it was everybody has Facebook, right? And so what was the first thing we would do? We would go look up our clients on Facebook, everybody. And we would say, okay, this person has Facebook, this person's profile is way too wide open. I see this person drinking in this picture. I see this person posting about their divorce. It's the first thing that we would do. Now, not everybody has Facebook. Now, a lot more people have Instagram. Some people, younger people have Snapchat. I don't have Snapchat, but somebody in the office does, so we can look people up if we need to. But, everybody has all these different accounts, and that's totally fine. But when you're going through divorce, I got to tell you, the most common exhibits in divorce, especially in custody and financial cases, are text messages, Facebook messages, and Facebook posts, where so-and-so is posting about their divorce, or so-and-so is posting about a financial trip they took, or when they were saying they had no money to pay support, or they can't afford this or that. Or someone's posting about drinking or smoking marijuana or whatever when there's a custody issue. And you might think, oh, my Facebook is restricted and it's really locked down, but you might have a mutual friend who's not really your mutual friend, or you forgot about, that has a friend with someone else, and they have provided screenshots to the other person in the litigation. And all of a sudden those are exhibits in a divorce. And that happens so often, and you just don't want that to happen. So it's really important to restrict your social media accounts. Sometimes consider a hiatus from social media during this time, but really old Facebook and social media, Instagram posts, all kinds of things like that can kind of come back to haunt you. It's really sad, but it's really true. So be very careful about your social media. You might want to go through and scrub those college posts from 1999. I guess those weren't really on Facebook. Facebook wasn't around then, but 2008 or whatever. So be careful about those things that you don't want to come up. Take them down, or old text messages. Everybody has old text messages with their soon to be former spouse that they probably regret. I think everybody has angry text messages. Angry text messages are fine. Those are excusable. Threatening text messages are extremely problematic and can lead to what is called an immediate restraining order or domestic violence protection order. So be careful about text messages. Even if you're angry, what I recommend is don't respond when you're angry. Put your phone away. Don't do it. text messages can lead to very, very regrettable situations. Also, too, explanations if someone leaves you and you're very desperate, explanations later of saying you were desperate if you texted some kind of suicidal ideation, especially if you have children, can lead to disastrous consequences for you in parenting time. So even if you didn't mean it, don't send desperate text messages. If you really need help, call someone and get help. Don't send them to your former spouse. That's something I gotta tell you. So social media, that's my really quick spiel on be careful with your social media during divorce. Next thing, conduct yourself with dignity during your divorce. I tell my clients this. I try to do this in my representation of people. Some attorneys do not. Some attorneys will be extremely, extremely unprofessional, and they will take on the personalities of their clients, and they will get down and a paralegal said something that her attorney taught her 25 years ago was don't roll in the mud with pigs. And that is exactly true. Some attorneys will roll in the mud with the pigs, and some clients will do that. Don't do that. Don't say nasty, horrible things about your spouse in declarations or mediation letters. Don't throw mud at the other person. That is what family court is known for. That is what people do. People say awful things. And the court hates it. The court actually doesn't like it. They're used to it. They don't, it's kind of loses, it's kind of like crying wolf. You say so many bad things about someone that it loses kind of shock value. You be factual. If something really bad happened, by all means say it. But it's different of saying, you know, John hit me and held me down and choked me than saying, John is a total blank, 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 whatever, and did that. Just stick to the facts. You know, no one needs your color commentary. Obviously someone can draw inferences about the kind of person John is if he did that. You don't, and also John's a terrible father. Okay, no one needs to hear that. If John did it in front of your child, just say John did it in front of your child and leave it at that. No one needs to hear that you think he's a terrible father. The court can figure that out. So anyway, so stick to the facts and highlight the facts. That'll get you much farther in front of a court. That will help the mediator, if you're using a mediator at the time, see the kind of person this is. Stick to the facts. It will get you a lot further. I can tell you that. It'll earn you a lot more respect. That's the kind of thing that helps you. But don't roll in the mud with pigs. That's one of my favorite things to say lately. So anyway, and it earns you a lot more negotiating power when negotiating with other attorneys. So that's what I try to do. Anyway, so yeah, all these really ugly family law declarations too won't get you very far, and they'll waste a lot of time and money that you'll wish you'd spent actually resolving problems. So sometimes, you know, clients will want you to just be uglier and uglier, and we'll fight hard for you, but we won't, you know, just say things that aren't going to get you anywhere, and they're only going to really make the court mad. So don't conduct yourself with dignity. That's part in court. That's part one, and in mediation. Part two is co-parenting. You might not, at the time of divorce, if you have children, you might not like the other person at that time that you're going through this with, but keep in mind that unless it's a really extreme situation where this person is going to be, the other parent is going to be restricted from parenting time, you know, indefinitely, this is someone you're going to have to co-parent with. So keep that in mind. And even though if a divorce is contentious, keep in mind that unless you don't have children, you're going to have this person in your life, and you're going to have to co-parent. So the best thing you can do is try to get through the divorce with them with some level of dignity, and you should never disparage the other parent in front of your child. That may seem obvious, and you might not do it intentionally, but children are smart. They're smarter than we think, and they know what's going on. And putting a child in the middle of a divorce is the worst thing you can do, and it will backfire on you. And I'm not saying anybody on this webinar would do that, but it happens. And it also too can happen where a guardian ad litem, I've had a guardian ad litem maybe involved and speak to the child and say, oh, well, mom or dad said this, and the parent might have thought the child was listening, or it can just be a terrible, terrible thing. And you don't ever want that to happen to you. So be careful. Children are always listening. Be careful, even if you're, you know, talking to another adult, you might not think the child knows, but just be really careful and be protective of your child, and always don't disparage the other parent, especially while you're going through the process and while your child is around. You can say that in private by all means, vent, but don't do it. And don't do it with your child. You'd be surprised how some parents think, oh, I have a teenager, I can say, your dad's this or that. Don't do it. Just please don't. Next thing, before we get to some do's and don'ts, more do's and don'ts. Dispute resolution. I get a lot of questions about dispute resolution. What does it mean? What's it all about? What is mediation? Do I need an attorney for that? There's a lot of different approaches to mediation. First, I should ask Melissa, do we have questions?
We just have one so far.
All right. I'll just take that really quick, and then I'll move on to dispute resolution.
Okay, and also just a reminder to everybody, please, if you have specific questions, or other types of questions that come up for you, please go ahead and put those into the Q&A. Question here is, does Washington state favor the woman or the man in any way? I've been married for 5 years with one small child. Feel like I'm being emotionally abused, but not sure how I can prove it. Just wondering if I'm battling an uphill climb.
No, you're lucky. I don't know if you're the woman or the man, but no, Washington, there's no presumption for the woman or the man. A lot of people will say, I don't know why, people will say, oh, Washington's mother friendly. Actually, no. I don't know either if you have children. It doesn't really matter, but Washington,
one small child.
Yeah, no, Washington, there's no presumption for the mother and there's no presumption for the father. Washington has what's called a best interest standard. A parenting plan is not, there's no presumption for either parent. It's the best interest of the child. I've had plenty of dads who are primary parents. I've had plenty of moms who are primary parents. So no, there's no presumption. And what is going to go into who's primary parent is a lot of factors, but sex of the parent is not one of them. So that's good for you, I think. I do think that if you feel like you've been emotionally abused and you feel like you are fighting an uphill battle, it's really important to kind of take stock of where you're at in the process and kind of what your next steps need to be to sort of maybe take back some of the power in this situation. But, don't feel like if you're the dad, oh, well, mom's going to win no matter what, because that's not the case. Maybe if mom's always been primary, you might have an uphill battle with that. But I will say too, it can kind of depend on where you're at. King County, there is a growing presumption for 50-50 and equal parenting time. Pierce County, that's a little bit more of a new thing, unfortunately, but and Snohomish a little bit too, but definitely in King County, the presumption is now more than ever that dads should have every bit as equal of residential time unless there are limiting factors as mom should. So no presumption for mom in Washington state.
I just want to add to that, if it's a situation where there is emotional abuse, try to be really mindful about making sure that you have positive supports and outlets in your life so that you can make the most healthy decision for yourself. When there's emotional abuse, it can be very cyclical and very manipulative. And so it can be really difficult to kind of get caught up into the cycle of kind of being on the verge of wanting to make a change. And then the partner who's emotionally abusive can kind of turn it around, and now they're acting amazing and treating you wonderfully. It's a very manipulative cycle if somebody's an abuser. And then you kind of get off track from where you were and then find yourself kind of back into the same pattern over and over again. I don't know if that's your experience, but I just want to make sure that you're thinking about it and being mindful of the cycle that can exist, and just making sure that you have, either counseling support or certainly positive social supports to help you feel supported so that you can make the right decision for yourself.
Yeah, absolutely. I think you can't really, you can't, I don't think you can really underscore that enough, absolutely. That's, yeah. I'll go back to dispute resolution because this is a big one that comes up, I feel like more and more and more. So mediation, there's a lot of different approaches to mediation. I would say there's not even, someone just asked if Snohomish is mother friendly. I don't think there's a universal approach to that. I would say Snohomish is a little, I don't even want to say definitely that Snohomish is always mother friendly. Snohomish is not as 50-50 friendly. So Snohomish is kind of more primary parent friendly. Snohomish doesn't grant as many 50-50 parenting plans as King, but I would say if a dad's had primary more than mom, Snohomish is probably going to go with dad. But Snohomish also too has has had a little more turnover lately than they have had before. So it's not all the same people there that were always there before. So Snohomish is a little more likely to not always go 50-50 the way that I think King has, but it's going a little more that way. There have been trainings that guardian ad litems and parenting evaluators that have attended statewide over the last couple of years, and the AFCC, which provides trainings that everybody has been going to, that really dictate that 50-50 plans, and not even 50-50, but 60-40 plans, even if 50-50 is not appropriate because the parents might not live close enough or whatever, but more equal parenting time is seen as more advantageous than just the every other weekend that used to be a lot more common. So even Snohomish is kind of getting on board with that a little bit more. Pierce and Snohomish. King has definitely embraced it a lot more. Well, it wasn't even that long ago. I want to say it was, and I know I'm digressing a little bit, but I want to say it was maybe maybe it was a little while ago, but I remember one time trying to enter a 50-50 plan that was agreed. Maybe this was 6 or 7 years ago. This was one of the last times this happened. And so I remember taking it down. It was in King, and I took it down to enter a 50-50 plan. And the court was like, whoa, I don't know if I want to enter this. And that used to happen sometimes where a court would kind of balk at entering a 50-50 plan. And that was not as common. And now it's like, it's a given. So, yeah, no, I didn't. Snohomish, I wouldn't say necessarily is mother friendly, but I would say Snohomish is not as 50-50 friendly, although it is going a little more that way than it ever was before. So to answer your question, and we will get to the question about alimony, it looks like I see. But dispute resolution, I do want to cover that quickly. Mediation. So mediation is required in King, Pierce, and Snohomish counties. It's required in every county of those 3 counties. And it's also required in Kitsap, although they do it a little bit differently there. So let's talk about it. Some people will say, oh, I want to mediate and I want to do it without an attorney. And you can do that if you want. However, I've had a lot of clients come that mediate without an attorney. And what you do when you do that is you sometimes will go to an attorney mediator who can't really advise either one of you. They act as a neutral, where they try to help guide you to a settlement. And they're not advocating for either one of you, and they can't give either one of you legal advice. So they can't really tell you, this is better for you or this is better for you. And the reason why is because the rules of professional conduct for Washington state attorneys don't allow us to do that. They allow us to act as a neutral, but they don't allow us to basically act as the attorney for 2 parties. It's the same reason that you can't have the same attorney. The reason why is that in a divorce, you're not similarly situated. You guys have adverse interests. And think about it. Here's why. If one party comes to me, somebody asked about maintenance, so I'll use this as an example. If one party comes to me and says, let's use round numbers, I make $150,000 a year, and the other party comes to me and says, I make $50,000 a year, and it's a 10-year marriage, well, one party is going to be likely entitled to some significant spousal maintenance, and the other party is going to be the one paying it. So I would tell one client, if I was representing the $50,000 a year client, you should be asking for spousal maintenance. And I should tell the other party, you should be trying to settle on paying less spousal maintenance. I can't give them the same advice. I can't ethically do that. So a mediator can't try to tell them that either. They can just try to help them agree on something, So a lot of the time, not a lot happens that's effective, and you don't have anyone to advocate for you. So you can go to a mediation like that, but a lot of the time things don't get resolved. And especially too, they also cannot help you execute documents. You then have to leave, and you leave with what's called a memorandum of understanding, or an MOU is what they call them, with what you think you agreed upon, but then you have to take it elsewhere and have someone draft it and execute it for you. So I am not a big fan of that. It also is a situation where sometimes one party will feel like they don't really know what happened. So it's not necessarily great unless everybody's really similarly situated. If everybody's kind of on equal playing field, it's great, but that's not always the case. A very common mediation, the way that we typically do it, and the way that I think is really effective is what's called a shuttle mediation. Shuttle mediation is what is most common with attorneys, and it's most common in settling your case and keeping it out of court. It's most common in what we call a cooperative divorce, and sometimes even a contested divorce ends in a shuttle mediation as well. Shuttle mediation is where you have advocacy and you have privacy in mediation, but your case will settle essentially in that one-day mediation by the time you get there. So you might be sitting with your attorney in one room, and the other party would be sitting with their attorney or on their own if they don't want an attorney in the other room. And then you have the mediator, who's usually also an attorney, going back and forth. And that is usually an evaluative mediator who will go back and forth and start to evaluate and kind of give their opinions in each room and carry offers back and forth. And you can sit in your room and you start with your offer. The other person starts with their offer, and you have the privacy to get your advice in your room and cry if you want to cry and yell if you want to yell, and have privacy in your room to get your advice and kind of negotiate. The other side's negotiating, and then the mediator goes back and forth. And in all the years I've been doing this, most of the time, it might be a long day, but the case settles because everybody's there, everybody has skin in the game, and we get it done. I've seen cases that have been very contentious that we never thought were going to settle, and they settle. When right now we're doing most of these via Zoom. Other times we do these all under one roof, just in different rooms. So it actually works really, really well. And like I was saying, King, Pierce, and Snohomish require dispute resolution, whether it's mediation or arbitration, to take place before your case can go to trial, because family law judges, or any judges, they don't want to make decisions about your finances, about your children. They want you to make those decisions. So mediation is, I think, a fabulous way for you to have control and say over your case. In some cases, you can do this a lot earlier. I've had people who say, you know what, we just want to exchange our financials early. We want to get into mediation as soon as we can, and we want to get this case done. That's great. I think that's wonderful. In some cases, that's not practical because we need to go through discovery, or maybe we need to have a parenting evaluation. You know, some cases that's not practical and we have to do it later in the case. But in some cases, we can do it soon and the case can be over, and that's great. So mediation is a really, really important tool. I'm also a trained mediator, and I love mediation. I can't say enough good things about it.
So there is a question here in the chat
Yeah.
About mediation.
Sure.
What if the other party refuses mediation? Does it automatically go to court, or how can they, what happens if they're trying to refuse it?
Well, then they can get ordered to go to mediation, and they can get paid the fees. They have to pay the fees for us bringing a motion to have them ordered to mediation. I've had that happen too. And someone says, no, I won't go. Well, if they won't go to mediation, then we bring an order forcing them to go. And if they don't go, then fine, they'll have to be ordered to pay the fees for that. And then you basically would show up to a trial and get everything you want. So yeah, if someone's refusing, maybe they don't completely understand the situation and they have to be told, and that's too bad, you know. The only thing you got to know about that, though, is you might want to go earlier. I've had to break this to certain clients. You might want to go earlier. You might be like, let's just go now and get it over. I've had so many people say that, but this is where that in King County, this is where it can be, if you're not both aligned, but doing it early, you're going to have to wait. So in King County, when you file your case, the case schedule will issue. And a case schedule is because there's so many cases in King County. We have 2 courthouses. We have one in Kent for cases that are below I-90. And we have one in Seattle for cases above. And there'll be a case schedule issued, and that will tell us what the schedule is going to be. And it'll have a trial date that's about a year out. So it'll also have an alternative dispute resolution deadline date. And that's going to be about 1 to 2 months before your trial date. So if someone's saying, I don't want to mediate, I want to wait, you can't force them to mediate until it's the dispute resolution deadline. So I'll have people that say, I want to mediate in like month 3 or 4, and you know what, I can't force them to mediate until much later. So sometimes that happens. And, you know, the court's not going to compel them to mediate, you know, in June if their dispute resolution deadline is in November. So sometimes you're kind of stuck dealing with that just because cases move slow in King County. The last thing I'll say about mediation is that the mediators you choose are extremely important. There are a lot of well-known mediators in King County. There are retired judges that mediate. There are family law attorneys who have retired from practice that have just been doing mediation, who maybe practiced for 30 years. And I firmly believe that the mediator you choose, and knowing your case and knowing your client and knowing the issues in your case, the people that you choose to mediate with are extremely important and instrumental in settling your case. So that's when you have to trust your attorney too, to pick the right people. So that's critical. So that's mediation. Arbitration is also another way to settle your case short of trial. A very common thing is mediation arbitration. So maybe you mediate, and if we don't settle a few things, we can submit them to arbitration. I do that with personal property a lot. I had this case I like to talk about a few years ago where we settled almost everything, but these people were like really hung up on these vintage movie posters, like, and this is one of my don'ts. Don't spend thousands of dollars fighting about $100 of personal property. These people were literally fighting about these Star Wars posters, and they're spending hundreds of dollars for me in one room to fight about them. The other attorney is spending hundreds of dollars in the other room, and the mediator. So we're spending like $1,000 an hour to fight about these posters. And finally, me and the other attorney are emailing, and we were just like, can we just submit this to arbitration, because this is getting ridiculous. So they're spending way more money than the value of the property. So submitting something to arbitration, like personal property, just means we submit a written statement, they submit a written statement on their position, and then the arbitrator makes a decision. So arbitrating on things is sometimes a good way to avoid actually going to trial on them, but still getting a decision. So that's all I'm going to talk about for dispute resolution. Melissa, do you have, and then I'll move on to other things.
Yeah, just the question that's on here about alimony, maybe if you want to grab that one. It says, how does alimony work and how is it calculated?
Yeah, I have that on my list of things to go over. So I'll do my little outline of spousal maintenance. Spousal maintenance, you talked about alimony. I'll give you the little once over on spousal maintenance. Spousal maintenance is the Washington term for alimony. In Washington, we use very friendly terms for things. We don't use custody, we use residential schedule. We don't use alimony, we use spousal maintenance or spousal support. So when someone uses the word spousal maintenance or spousal support, what they mean is alimony. So that is a payment to a spouse that is made post or either post divorce or as a temporary support payment during a divorce. How does that work in Washington? You know, I'm going to tell you this. This is one of the most contentious issues and the most open to interpretation issues that there is basically in Washington domestic law. We do not have a statutory formula like California does or some other states do. And we also don't have fault-based maintenance. Washington is not a fault-based state, so spousal support cannot be allocated based on fault. If someone cheats on you or hits you, you cannot get maintenance for that. Washington maintenance is based on, there's a statute that governs it, but it is not allocated based on a formula. So there are factors that determine maintenance, but there is not a formula. So, okay, the basics. Washington will look at, first of all, I should talk about, before this, I should talk about community property, but I'll get to that in a minute. So the basics are this. Washington marriages are broken up into basically three categories: short-term maintenance, a midterm marriage, and a long-term marriage. Short-term marriages are generally thought of to be 5 or 6 years or less. Midterm marriages are kind of everything from 5 or 6 years to around 22 to 23 years, and then long-term marriages are 22, 23 years or more, okay? Short-term marriages, the goal of a short-term marriage is essentially to put the parties back where they started. A midterm marriage is to be more rehabilitative in nature, and a long-term marriage is essentially to equalize the parties into perpetuity, okay? And when we're talking about maintenance. So maintenance also too is done very much in tandem with your property division. So you can't really talk about one without talking about the other. Maintenance is not going to be the same for everyone. Maintenance is very much determined based on the income of the parties. Not every marriage is going to have maintenance, but you might remember that example I gave earlier where I mentioned one party making 150 and one party making 50. Okay, if that's the case, it's very likely that one party is going to be paying maintenance to the other, or you're going to have a disproportionate property division. So a couple things to know. Washington has a basic sort of a standard, and it's not codified into statutory language, but there are cases that talk about it, and there is a basic sort of a standard that is commonly accepted about the ratio of years of marriage to spousal maintenance, and this is for post-decree maintenance. So post-decree is post-divorce is what I'm talking about. And some people will say it is 4 years of marriage is 1 year of maintenance. So if you're married for 4 years, you might get 1 year of post-decree spousal support. Some people will say that flexes down to 3 years. So 3 years of marriage is 1 year of post-decree support. So for example, if it was a 12-year marriage, the ratio is going to be somewhere of 3 or 4 years of support. It's going to be somewhere in there. That's pretty reasonable. However, in order to get that level of support, you also kind of have to have a need, and that would be in a midterm marriage. And so the court doesn't really want to see you exiting the marriage with one person living in a big house and one person living in a studio apartment. In a midterm marriage, the goal, like I said, is rehabilitation and eventual equalization, exiting the marriage and then rehabilitation. So the parties would leave the marriage, basically equalizing income, and then maintenance would step down. So maybe you leave the marriage with the parties equalizing from maintenance, and then maintenance tapers off. And the idea would be that the person who makes less either rehabilitates themselves or gets used to just having less if they're not going to, go back to school or get another job or do whatever they're going to do. In a short-term marriage, the court's going to look more at factors like, can this person afford to support themselves? Do they just need a little bit of support leaving the marriage? And so on and so forth. In a long-term marriage, the court's going to look at things like how many years are we looking at to retirement? Do we need to equalize these people to retirement? Are they going to be equalized in retirement? What are their Social Security benefits going to look like? What's the, is there retirement? Is there pension? And we're going to look at a lot of other things there too. So maintenance depends on the income of the parties, the length of the marriage. It also depends heavily on the property division. Community property, I cannot talk about maintenance without talking about that. So I'm going to talk about that basically for just a minute. Community property in Washington, we are a community property state. You probably have heard that or know that, but we are not a 50-50 state. A lot of people have, this is another misconception I got to touch on before we go today. People think that Washington is a 50-50 state. No, it's not. So don't think that. If you do think that, you're not alone. I think it's because California is a 50-50 state. So what that means is no matter how long you're married, no matter how much money anybody makes, they just divide all community property 50-50. That's not the way it works here. That's why length of marriage, like I was talking about in the spousal maintenance portion, and income really matters in community property division, and they go hand in hand. Washington, the division of community property is a just and equitable division. Those are the magic words. So because we are a just and equitable state, the court wants to know the length of your marriage. They want to know how long you were married. They want to know the story of your marriage. They want to know how much somebody made. They want to know, did somebody stay home for a while and take care of kids and give up their career for a while? They want to know, is somebody going to recover from the divorce faster financially because they make more money? They want to know that, because if somebody makes less and somebody makes a lot more, the more moneyed spouse is going to recover faster financially than the less moneyed spouse. And so, in a short-term marriage, we're going to come a lot closer to an equal division because parties are probably going to go back to where they started. But in a longer marriage, or even a marriage where in a short-term marriage where one party makes a lot more, we're still going to have a disproportionate division, or we're going to have an equal division plus maintenance because, we've got to do equity. And if one party is going to exit the marriage with the ability to make a lot more money quicker, we've got to do equity by putting that other party in unequal footing, at least for a little while. So you might be looking at a 60-40 division in favor of the financially disadvantaged spouse. So it really depends on your situation as far as maintenance goes and community property division. So again, this is why I cannot stress to you enough that these situations are not the same for everyone. These situations will impact your future, and these could be swings of 10, 20, 30, 40, 50, even $100,000, $200,000 in even small communities. Now, if you're talking about a bigger community that's worth, a couple $1 million, even more, these swings can be even bigger. So you really want to take the time to meet with an attorney, go over your finances, and figure out what is your range of settlement, because you could be giving up a lot that you don't know. Absolutely. So maintenance and community property are big. Child support's a lot easier. Child support is something in Washington that's based on a statutory formula, unlike community division and spousal support. Child support is based on a statutory formula that's based on the income of the parties, the age of the child or children, and the county they live in. Basically plug in the income of the parties. You can take out a maximum retirement calculation of $416 a month. You can take out the taxes. There's a calculator, and we can say, hey, here's what child support's going to be. Here's what the proportional share is for expenses. And child support caps out at $12,000 of combined income a month for the parents. And if people don't make that much money, that's okay too. Child support is less. And if one parent's not working, they're voluntarily underemployed and they can be imputed in income. So child support is basically on the numbers. There's not as much guesswork, but there's a lot more for interpretation for spousal support and community property division. I did want to run through just some basic do's and don'ts. Really just, yeah.
We just have one more question in the chat. I don't know if you want to grab that.
Yeah, go for it.
There's a couple, but we could do maybe one and then see.
Yeah, just go ahead.
Okay.
That's fine.
Some general questions. How does unstable mental health of a partner influence the process of legal separation? Do you ever see people who reconcile during the process of legal separation? And can you choose to dissolve the legal separation if reconciliation happens after the papers are filed?
Yeah, I mean, all the time. I'll be honest with you. There's no reason not to be. Yes. Legal separation. I should give my 2 minutes on legal separation and divorce. Legal separation. Yeah, we've had people reconcile in the middle of divorce or legal separation. You can dismiss your divorce petition or legal separation at any time. I'll be frank though, almost every time I've had someone do it, they end up filing again. I can think of maybe 2 cases where they haven't, but we just had somebody dismiss last summer and came back in a really bad situation, which we kind of saw coming. I mean, it happens. I hope that doesn't happen every time somebody dismisses their petition, but it usually does. I hate to be the Debbie Downer about that, but it just usually does. But a couple times it hasn't. But mental health plays a factor in many of our cases, actually. Many. Especially like narcissist issues, DV issues, control issues. And I think this kind of comes down to knowing when to file, knowing how to approach the other party. Unfortunately, these things play a really big role. And, you know, a lot of the time, I will say, you spend a lot of the time in these kinds of situations where your partner has a mental health issue, thinking that if things get better, the relationship can be better. If things get better, if this person gets the help they need, the relationship can be better. And I think sometimes that's the case, but you know, sometimes people spend a lot of the time trying to find that right combination or that right thing, and then it just doesn't happen. But yes, you absolutely can dismiss a petition at any time. No one's going to force you to go through with it if you don't want to. Sometimes, you know, people will file to send a message or to draw clear boundaries or to really separate or to protect themselves financially. But you can totally do that. The other thing to know about legal separation that's important, I must bring up, is if you were to complete a legal separation, completing a legal separation separates you financially the same way that it would with divorce. Legal separation does absolutely everything a divorce does. You still file separately on taxes. You are completely separated from that person. If you had kids, you would still enter a parenting plan even. You could still pay spousal support. It's exactly the same. The one thing that's extremely notable is that 6 months after a decree of legal separation ends, either party, either the petitioner or the respondent, can convert the decree of legal separation to a final divorce without the other party's agreement. So either party could convert it to a divorce, and there's nothing the other person could do about it. And it can be done very easily. It's very simple. You just basically file it and do it. So some people will file legal separation and then convert it, but you have to wait 6 months from the time the legal separation is filed. So that's something a lot of people don't realize, but I think it's notable.
There is one more question here, and I noticed that we're at 2 o'clock, so
I'll go a few more minutes if you want me to answer this. That's fine. Go ahead.
What about property and funds you've made before marriage? With long-term marriage, it can be hard to prove. Banks don't keep records long enough.
Yeah. Oh, long-term marriage, this is super important to note. We didn't have time to get into all this. Please come to a webinar on community property that we'll do. In a long-term marriage, all property is before the court. The court can invade separate property and often will in a long-term marriage. All properties before the court. If you have a long-term marriage, especially a marriage is 25 years or more, and you have post-marriage property, if you have an inheritance even, inheritance is generally separate property under Washington law, but if you have a lot more than someone else, or you have post-marriage property, the law in Washington is to equalize. So the court's going to look at it, and they're basically going to want people to be equal. So it can be difficult to trace separate property, but the court's kind of not going to care either. So they're going to look, and they're going to want to see you equalized. Also, too, another thing to know is if you have a committed intimate relationship and you live with someone in a committed relationship prior to marriage, you might want to keep in mind that community-like property rights attach prior to marriage. So please keep that in mind. That's a whole other conversation for another day. But community-like property rights attach prior to marriage in Washington, and that time will be counted. So property rights can attach prior to marriage that way as well. So I guess we're out of time, so I didn't get to cover everything, but I think we got to cover a lot. Thanks a lot for joining us. I'll let Melissa share some contact information, and we'll see you next time. Thank you so much. Take care. Thanks for joining us today.
Thanks for joining us. I'm just going to leave our contact slide up there for just a moment in case anybody wants to copy down information.
Yeah, please feel free to reach out. Love to talk to you. And we'll have another webinar next month. And also, too, please feel free to join our do's and don'ts of divorce and separation workshop. You will get an email about it. We do meet monthly, and it's another great opportunity to ask questions and meet with some other professionals that are part of our crew and dive into more of these topics in more detail. So thanks again. It was a pleasure to have you. Take care.
Take care. Thank you.